It's an event put on by the Haldane Society of Socialist Lawyers. I'm sure many of you know who we are. We are an organisation for anyone who's remotely interested in or connected to the law, but we are proudly socialist. We produce Socialist Lawyer magazine 3 times a year. We organise conferences and talks like this one. We organise legal observing, and if you're interested in joining, please do come and see us. There are 3 speakers tonight. First, on the left is on your right is David Watkinson, who I first came across at an event not dissimilar to this one when he was introduced as David Watkinson on account of his long and illustrious career representing persons unknown in all sorts of legal disputes. He, unlike me, is lucky enough to have lived in a better time when tenants had security of tenure. I was born the same year as Thatcher's Act, so David is going to tell us a bit about the history and about what life could be. Sitting next to him is Izzy Kirksall, who's a member of Housing Action Southwark and Lambeth, which I will shower with praise because I'm also a member of Housing Action Southwark and Lambeth. But they are a phenomenal campaigning and direct action casework group based in South London, working on poverty, housing and related issues. And finally, if there's time, you'll hear a few words from me before moving on to questions. So unless there's anything else, can I ask you to welcome David in the usual way?
Thank you very much, everybody. Well, you haven't heard me speak yet, so you might change your minds. I'm going to stay sitting down, if you don't mind. And if any of you have got any problems in hearing me, then please let me know. Well, as Nick has said, I'm going to be talking to you about the consultation paper on abolishing Section 21 of the Housing Act 1988. But I'm also going to tell you about what led up to the Section 21 and what has gone on since. So I'm going to take you on a journey back to the time of the Rent Acts. Now, when James Brokenshire, Ministry of Housing and Local Government then, on the 15th of April 2019, announced the government's intention to end no-fault evictions in the private sector, as Nick said, there was an audible gasp of surprise that went right round the English housing world. But the surprise was instantly replaced by a question. So, if there are not going to be no-fault evictions, what will the with-fault evictions look like? We were promised a consultation paper. A few days before Mr. Brokenshire ceased to be in office with the arrival of a new Premier, we got it on the 21st of July 2019. A new deal for renting. Reply by 11:45 a.m. on the 12th of October of this year. If it goes in on 11:46 a.m., you've had it, and your response will not be looked at. Now, we have been here before, so before I turn to the consultation paper, I would like to take you back to the Rent Acts and background history. The Rent Acts, 1968 to 74, were in force when I first got on my feet as a barrister in January 1973. Effectively, the Rent Act ceased to operate after the Housing Act 1988 came into force. So it is just possible that not all of you have included the Rent Acts in your practice and experience. This came home to me when, a couple or so years ago, I went to the Brockwell Park Summer Fair. I was actually going to visit my daughter who was personing the stall of shelter. And talking to one of her colleagues, and we were talking about Section 21 and its effects on renters and the disruption that it caused, etc. And I mentioned, well, there was a time when private sector tenants could not generally be evicted without the landlord proving grounds or reasons for eviction. And he looked at me as if I was describing some golden age that had existed in the distant past and now had vanished into oblivion, which of course it had. But the Rent Acts have existed since 1915 and were the result of mass working class action in Glasgow during World War I. At the time, Glasgow was, of course, a major world port, a dockyard, a munitions factory, and supplier of young men to the front in the course of that war. Landlords took advantage of the war to raise rents. There were rent strikes. Eviction orders were sought. But the landlords' agents, the factors, weren't able to collect rent or enforce possession orders because of the crowds, chiefly women, who blocked their way. Then they had the idea of applying to the sheriff's court, that's the civil court in Scotland, for debtors' orders, which would enable them to attach the men's wages, amongst other means of enforcement. On the day the applications were to be heard, the dockers and workers came out to join the women, and what happened next is described in this book, Revolt on the Clyde, by Willie Gallagher. I'm going to read you an extract from it. On the day of the trial, Glasgow witnessed a demonstration, the like of which had never been seen before. From early morning, the women were marching to the centre of the city where the sheriff's court is situated. Even as they marched, mighty reinforcements were coming from the workshops and the yards. From far away, Dalmoor in the west, from Parkhead in the east, from Cathcart in the south, and Hyde Park in the north, the Dungareed army of the proletariat invaded the centre of the city. Into the streets, around the sheriff's court, the workers marched from all sides. All the streets were packed. Traffic was completely stopped. Right in front of the court, John Maclean was on a platform, addressing the crowd as far as his voice could reach. It was a great experience. Roar after roar of rage went up as incidents were related, showing the robbery of mothers and wives whose sons and husbands were at the front. Roar followed roar as we pictured what would happen if we allowed the attack on our wages. Inside the court, the sheriff and his clerks were white with apprehension. A deputation of workers, men and women, was demanding to be heard. The roars from outside were making the windows rattle. At any moment, the deputation might be followed by a surging, irresistible crowd of angry men and women. In such circumstances, how was it possible for a poor sheriff to retain any dignity? How was it possible to make play with legal technicalities and trivialities? There was no hope of the police doing anything. They were helpless. And what use is a court? What power has a judge, apart from the brute force they're able to employ? It was obvious to the sheriff that the situation was too desperate to play with. He telephoned to London and got put through to the Minister of Munitions, Mr. David Lloyd George. The workers have left the factories, he said, after explaining the character of the case. They are threatening to pull down Glasgow. What am I to do? Stop the case, he was told. A Rent Restriction Act will be introduced immediately. And it was, as the increase of rent and mortgage repayments War Conditions Act, 1915. So, please, just to say one other thing about that. I read pretty much that extract out in court once as a question had arisen as to the origin of the Rent Acts. And after I'd finished, my opponent got up and said that this was the first time that the memoir of a communist MP had been read in support of a legal submission. And he was not saying that as a compliment. So the structure of the Rent Acts. The Rent Acts only affect the private sector, by the way. As you know, protection for the public sector tenants was introduced by the Housing Act 1980. It's been chipped away since, but that topic is for another meeting. So, with certain exceptions, a tenancy in the private sector of a dwelling is protected, was protected under the Act. That is, the tenant could not be evicted except for reasons known as grounds. For example, rent arrears. causing nuisance and annoyance, what later used to be called, is called antisocial behaviour. The landlord or a member of his family wanting to live in the property, suitable alternative accommodation being available, and although this was not a specific ground, but it was still a circumstance that could lead to possession proceedings, the tenant ceasing to occupy the property. Some of these grounds, for example, arrears, nuisance and annoyance, the court had to find that it was reasonable to make the order in addition to finding the reason existed. Others, provided the facts of the grounds were made out, the possession order followed. That's the difference between discretionary grounds and mandatory grounds. In relation to the discretionary grounds, the court could suspend the possession order on terms, as well as, of course, making an immediate order. Please note, there was no ground for possession in the Rent Acts that the landlord wished to sell the property. We'll come back to that. Secondly, I'm going to move on and come back later. Can you observe a similarity between the grounds that I've described and those grounds for eviction that also apply to tenants in the public sector and to assured tenants, that is, not assured short-hold tenants, in the private sector? That's no coincidence, because the grounds for possession in the housing acts relating to public sector tenants and private tenants are modelled on those contained in the Rent Acts. Security in the Rent Acts was also coupled with rent control. Rent control was considered necessary as an adjunct to security, because otherwise the landlord could avoid protection by raising the rent. The tenant would run up rent arrears and a possession order be sought. System of rent control was that the tenant could apply to a rent officer who was appointed by the local authority, who would set a fair rent. What a fair rent was defined by Section 70 of the Rent Act 1977. The rent officer fixed a fair rent by considering criteria relating to the terms of the letting and the condition of the letting, amongst certain other matters. But crucially, the scarcity of dwellings to let was not to be taken into account. If neither the tenant nor the landlord liked the rent officer's fixing of the rent, which was effective for 2 years, they could appeal to the Rent Assessment Committee. And that was a tribunal consisted of a lawyer chair, an expert wing member, and a lay member. Now, landlords, particularly corporate landlords, were able to work the rent assessment system. It's often said that the existence of the Rent Acts discouraged landlords from letting in the private sector. But this is not necessarily the case. So far as protection was concerned, don't imagine that because a landlord had to prove grounds, it was all plain sailing in the courts. And Watkinson went through his early career hardly having to face a possession claim and going to certain success if any such claim was bought. Not a bit of it. Watkinson had a very busy time, and other of his housing colleagues defending possession proceedings brought in the private rented sector. For a start, there was evasion. Plenty of litigation centred around whether what had been granted actually was a tenancy, but was a licence instead, which didn't attract Rent Act protection. Landlords contested the applicability of the Rent Act by arguing that it was a letting for the purpose of a holiday. It's remarkable the number of places you can holiday in the United Kingdom and in its cities, and that the letting was not to an individual but to a company. There again, there were plenty of possession claims bought on the rent arrears, nuisance annoyance, and the owner-occupier, and the owner wanting to return to occupy or to take up occupation grounds. As I said, the evidence that landlords were discouraged is at the very least not clear. From 1957 until 1965, there was decontrol when the Rent Act ceased to apply to a large number of tenancies. During that time, there was a major reduction in the quantity of houses available for letting, the opposite of what you would expect if you were thinking that the Rent Acts discouraged letting. The reduction was as a result of the property which had become empty because of eviction, because there was no protection, being reduced by sale. Assured short-hold tenancies. Private sector lettings were overhauled by the Housing Act 1988. The assured tenancy was introduced for all private lettings, with exceptions, as in the Rent Act. Rent registration was retained, but now the registration was to be of market rents, not of fair rents. The grant of an assured short-hold tenancy was an exception to security. Initially, formal requirements were laid down for a tenancy to be an assured short-hold tenancy. It had to be in writing, it had to last for at least 6 months, it could last for longer, and a statement had to be included in the notice of letting, referring to the right to registration of rent. All those restrictions were removed by the 1996 Housing Act, and after that, assured short-hold tenants became the norm. They could be for fixed term or periodic, no writing was required, they could be terminated by a 2 months notice, the court would be entitled to possession. The later period, the procedure was altered so that a hearing in court of the possession claim was no longer required. The accelerated procedure that dispensed with the court hearing, and instead the judge considered whether or not to make a possession order on the basis of written evidence unless the tenant, by responding to the notice that the procedure was being operated, persuaded the judge to order a hearing. Now, why did all this happen? Specifically, the provisions relating to assured short-hold tenancies. It happened, I suggest, because of the operation of the same ideology has led to the reduction in council house building, the right to buy, restrictions on trade unions and local authorities, deregulating financial institutions, The approach being that public provision is bad and should be restricted, and private provision is good and should not be restricted. Recognise all that from the 1980s. Now we've reached a position where the abolition of Section 21 has been proposed by the government. That was an astonishing reversal for such a flagship policy that had been lauded as increasing private sector provision. Many have campaigned about the injustice of the system, its contribution to the housing crisis, the disruptive effects on occupiers, but it was still a surprise, especially as the government in 2018 had consulted on mitigating the effects of assured short-hold tenancies by extending the length of tenancies in a consultation paper snappily entitled "Overcoming the Barriers to Longer Tenancies in the Private Rented Sector." There has still been no publication of the government's response to that consultation, although it concluded about the middle of 1918, except as can be gleaned from comments on it in the current consultation paper. So how did this change of heart come about? I suggest the reason was the effect of steady pressure from campaign groups such as Shelter, Generation Rent, Acorn and Hassel, coupled with an analysis of the 2017 results showing that the majority of renters voting Labour were voting Labour, as opposed to the majority of owner-occupiers voting Conservative. There were sufficient in the government minds to come to the view that steps needed to be taken to bring Generation Rent into the fold. So beware, they're looking out for you. Now to the consultation paper itself. It's to do with more than the abolition of Section 21. It's actually an overhaul of possession law in the private sector. As one commentator has said, you need a degree in housing law to respond to this consultation paper. But I hope that people will respond to it, housing degree or not. Paper repeats the government's commitment to repeal Section 21. We intend to deliver the intention to remove the assured short-hold tenancy regime. Once we abolish Section 21, there is no longer any significant legal distinction between a secure tenancy and an assured tenancy. Well, you can't get clearer than that. Paragraph 2.23 states the government does not intend to introduce any additional rent control. You can't get clearer than that. The government does not support the introduction of rent controls to set the legal level of rent at the outset of a tenancy. Historical evidence suggests that these would discourage investment in the sector, what did I say, and could lead to declining property standards as a result, which would not be a help to landlords or tenants. Consultation paper goes on to refer that fears that landlords might try to force tenants to leave by inserting a clause in the tenancy agreement increasing the rent to excessive amounts before any fixed term expires. So the government says that it would legislate to prevent this by requiring the post-fixed term rent to remain the same, subject to the current mechanism, which you'll recall provides for a market rent to be sent. There is a mass of other proposals, but I'm going to come to concentrate on the most significant of them in my view. First, there is a new ground for possession if the landlord wishes to sell, and it is a mandatory ground. If the court found the ground proved the landlord wished to sell, it would have to make the order. There is no requirement, if this becomes law, for the court to find that it be reasonable to make an order. There are certain limitations. The landlord is required to give notice at the beginning of the tenancy that he may intend to use this ground, although that requirement can be waived if the court consider it appropriate. The landlord would not be able to use this ground within the first 2 years after letting, subject to the judge's discretion. The landlord must give the tenants 2 months' notice of exercise this ground. This is entirely new. The Rent Act survived without any such ground throughout its entire history. The reason given for this new ground is to enable landlords to make decisions about their investment. So the question for the response to the consultation is this a proposal which should be opposed outright, or should it be made subject to conditions? The group ACORN has, and the group Ending Unfair Evictions, have circulated an open letter proposing that the landlord must prove the intention to sell by evidence of exchange of contracts. The Private Housing Tenancies Scotland Act of 2016 includes an eviction ground on the basis of intention to sell for market value within 3 months of the tenant leaving the property. The intention must be evidenced, and that evidence can include a letter showing that a solicitor or estate agent has been instructed to sell. That would be sufficient. A next proposal relates to student accommodation. Tenancies granted to students by specified educational institutions in the Acts are exempted from the assured tenancy regime, so they're not protected. The proposal comes in this way. A landlord letting to students in the private housing market would be subject to any other exception, letting on assured tenancy grounds once the Section 21 goes. However, the consultation paper proposes whether landlords should be enabled to gain possession if, having let to students, the course has ended and the property can be used by new students if the previous students have been evicted or not, as the case may be. This will be a matter of concern, I think, for students who want to stay, work or live in the localities where they have been based during their study, where they've been put down roots. The accelerated procedure. It is proposed that the on-paper possession procedure, previously only used in relation to assured short-hold tenancies, be extended to all mandatory grounds. So this would include, amongst others, the new ground that the landlord wishes to sell. It also applies to the returning owner-occupier ground, which it is proposed to extend for use not only by the landlord himself, but also the landlord's children, spouse, and other unspecified family members. The ground the tenant has 8 weeks to 2 months rent arrears can be evicted on a mandatory ground is also going to be restructured and become a claim subject to paper consideration if this proposal goes through. Remember, these are grounds which, if the court is convinced apply, lead to immediate possession orders. If extended, it will include grounds where the facts may be disputed and whether a tenant learns of the hearing depends on the efficiency of service of the notice of hearing by the landlord's agent or by post. And if those means of service fail, the tenant will be trying to set aside an order for possession with a bailiff date for eviction looming and limited time within which to find legal advice and drafting the papers to file at court. And finally, transition. Usually, when a Rent Act or Housing Act has come into force, its provisions have been effected at that point. So existing tenancies became protected by the Rent Act or by the Housing Act, as a case may be. That is not proposed here. Assured tenancy protection will apply only to new tenancies after the Act has come into force. So all existing assured short-hold tenancies under this proposal will continue until they come to an end. Also, it is proposed that the Act does not come into force until 6 months after royal assent. The result of all that is that assured short-hold tenancies could continue well into 2020 or 2021, depending when any bill that is introduced after this consultation period becomes an act. So, is this giving with one hand and taking away with another? Is it one step forward with 2 steps back, or the other way round? That'll be the matter for debate. We can welcome the end of no-fault evictions, even if fault evictions are extending their scope. Thank you.
Thanks very much. Izzy.
Cool, so I'm going to speak a little bit about our experience in our housing group as mostly private renters, our experience of Section 21 and sort of my more cautious and unenthusiastic response to the ending Section 21 and the campaign that was around it. And I guess I'm going to speak a bit about it from the perspective of private renters in our group who are at the worst end of private renting, and also about kind of building like a housing movement and housing campaigning and some of the frustrations. So I don't sound too much of a terrible person for not celebrating the end of Section 21. I just want to explain a bit about where I'm coming from. So Housing Action Southwark and Lambeth is a group of people. Most of our members are in severely overcrowded private rented housing, or they're in temporary accommodation provided by the council. And so in lots, and we have regular 2 meetings a month where there's 50 to 100 people. Lots of people in the group don't speak English as their first language, so we have translation. And we're in South London, so there are lots of Latin Americans. And so we have Spanish translation, we have Somali and Arabic translation. So we've got a really diverse group of people who are mostly in the private rented sector. And most of the time, even though lots of people are private renters, we talk about council housing and how do you access council housing and the housing waiting list. And so the members of our group, they're private renters, but they don't want to be private renters. They're sick of high rents, their overcrowded living conditions, really dodgy landlords harassing them. And they're looking for a way out of their private rented situation. And their landlord is more than happy to have them paying, as tenants, paying ridiculous rent. So actually Section 21 isn't an issue that comes up that much in our group, because we've got these really dodgy exploitative landlords who are just happy that the people are there and paying them money, and they're not bothered. And through the group, we've helped, that it's often very severe housing, like severe overcrowding, like really bad housing conditions, and we've helped people to get council housing through the group. And we've seen like the massive, like life-changing impact of that. And then those people have told their friends, and their friends have come along. And so at our meetings, we're talking about council housing all the time and how to access council housing. And so again, the Section 21 campaign it didn't resonate with people in our group that much. As I said, we don't actually get that many Section 21s, although recently, in the last few months, we've seen quite an increase of people coming with Section 21s. But often these are invalid. And when the Deregulation Act came in, that actually really helped, because there was this whole checklist of things that landlords had to do, and that all the landlords we're aware of weren't doing. or the landlords that we had to engage in. So we haven't seen a valid Section 21. People bring their Section 21s, and we had one that the landlord had just maybe printed off the internet or something, and it was meant to be like the yellow claim form for court or something, but it was black and white, and it didn't have the right court fee. And so, yeah, they're not doing it properly. And so, yeah, they're often invalid. But we have supported people in our group to get lawyers and to go to court and challenge the defence, to challenge the Section 21. Whilst working on another tactic, another strategy for their housing case, because ultimately they don't want to be in their shitty private rented situation. So it didn't. I spoke to a friend, Fozia, at our meeting last Thursday, and I was explaining about this talk, and she just didn't seem that interested and was like, well, they can, if someone has a Section 21, they can ask for help and you'll find a defence. And so I guess that's sort of our perspective and experience. And I guess, so we're one group, and our group has grown through word of mouth, so lots of people are in similar situations. Lots of people are in very overcrowded private rented or temporary accommodation across South London. But obviously there are other people, like families with no recourse to public funds in Section 17 accommodation, rough sleepers, people who are sofa surfing. And the campaign for Section 21 is like so far away from the realities of these people at the worst end of the housing crisis. So yeah, I haven't really got behind it, and our housing group hasn't. When it was announced in April, we have announcements at the start of our meeting about sort of like wider group issues before we talk about cases in our small groups. And we're like, oh, should we mention the Section 21? But our meetings are so busy, there's like 100 people and children running around, that we didn't even raise it, like to discuss it as an issue, because again, it was, people are like, how do we fight for council housing? How do we get on the list? Like, we've got decision letters from councils with stupid reasons denying people access to the list. There's just so many other things to focus on that Section 21 was quite far away from us. And I think with the Section 21 campaign and how it's been done, I sort of felt like it was quite narrow and was kind of whitewashing and sort of limiting the issues of private renters. So yeah, when the announcement happened from Theresa May, there was quite a lot of press coverage, and from these sort of so-called renters groups, there were these white middle-class people speaking about their Section 21s on the TV. And one woman goes, and I almost had to go to the housing office. Like, oh, imagine that. Imagine. And so it's really stigmatising of people who have no other option but to go to the housing office. Right? Our members go there. If you go there once, you're lucky. Like, you spend most of your day there and you make repeated visits to the housing office and you're treated so badly. And so the way this campaign was constructed by people was really snobbish and really like looking down at people who are in a worse situation. And I guess these sort of like middle-class people are really into defending the Section 21 because they've got nice houses to defend. Of course they don't like the inconvenience of having to move at not that much notice. But they always talk about Section 21 because they find somewhere else. They don't go to court and have to defend it. And they don't have to, when you go to the housing, say, oh, no, come back and wait for the warrant, meet the bailiffs with your children and try and arrange when you go to school. Well, do you go before or after the bailiffs? What's going on? Like, so the people who are at the front of the Section 21 campaign, these sort of white middle-class people, who just spoke about Section 21 because then they hopped off to somewhere else. Those attitudes, I thought it was a really unhelpful campaigning, and I was like really upset and distressed and insulted by some of the behaviour and the treatment. So yeah, it's just middle class people not wanting to move at short notice. But of course, it is more than that, and I do accept that, and I don't mean to sound flippant or aggy or anything like that, but that's how it felt a lot of the time. And if you wanted real renters' rights, if you want security of tenure, rent controls, like campaign for council housing because it's already there, right? If you want good security of tenure and you don't want rent increases, fight for council housing. And when you fight for council housing, not only are you hopefully getting a good result for yourself, but you're making sure that those who are way worse affected by the housing crisis, they're getting what they urgently, desperately need. And you'll benefit from it too, because if there's more council housing, that regulates the private rented sector in itself without all these new and confusing changes. So yeah, but again, they're too snobbish. Like these middle-class people on the news being like, oh, I got a Section 21. Imagine if they don't want to live in council housing because they're snobs and they don't want to fight for it. They're happy to rent from private landlords. Like I don't want to rent. And I guess, even the name Generation Rent is just like, like kind of indignant, like, oh, imagine renting, like I should be able to be owning my home by now. So I don't have a problem with renting if I'm renting from the council and my rent goes back to maintaining good quality council housing and goes back to building more quality council housing. Like I don't have a problem with affordable good council rent. Like, I grew up and benefited from it for like most of my life, and I'm one of the people, there's this, I guess, who didn't leave because I couldn't, like, so I was stuck with my mum. I guess all these different like bad housing situations, it isn't just Section 21, it's like overcrowding, people forced to stay with their parents, like it really is, it's like really terrible, like genuinely. But like, and so yeah, there was a Guardian report the other week that 8 million people are living in really bad housing conditions, and it was like millions are overcrowded, millions can't afford their rent, millions are forced to live with their family. There's all these like different wider issues other than just the Section 21, and I just feel that the debate around campaigning for housing just got really narrowed by this focus on Section 21. So narrowed and dominated by white middle class people, which is a really big problem that we should be thinking about and addressing. I guess when we're thinking about abolishing Section 21 and campaigning in the housing movement, it's important to think about how you believe wider social change should take place and who should be speaking and who should be acting. So I guess my argument in short, and I'll do a couple of other things, but my argument in short is those at the worst end of the housing crisis are the ones we should be listening to and acting in solidarity with and supporting their demands. Like in our group, we talk about council housing, like secure quality council homes in our communities, migrant rights, so an end to no recourse to public funds, so actually those people can access council housing as well, because we don't want racist council housing where immigration restrictions stop people who need it from getting it. And an end to benefit freeze and cuts, like those are the things that I think immediately help the worst affected and that we should all be supporting. I felt the End Section 21 campaign drowned out these voices, sort of whitewashed what should be a diverse housing movement, and sort of legitimises private renting, like if it was just a bit more secure, it would be fine. Like I rented once from a private landlord, which I was angry enough about, and then I got an email from her, and she was also securing Britain's borders because she worked for the Home Office. And I'm like, could you be any worse of a person? We shouldn't be giving any money to these people in the first place. And yeah, in Hassel, no one wants to be a private renter, but it was these sort of people who are happy to private rent. They're just, but the conditions could just be a little bit better if I didn't have to move, like if I had more security. Like obviously everybody deserves security. I don't want to sort of. There are better things we should be fighting for in solidarity with those less affected. The Section 21 kind of drowned out those voices, and there's lots of practical ways to support those worst affected by the housing crisis. And like right now, and that council housing benefits everyone. So one quick thing, I guess just a few arguments, concerns and frustrations with the Section 21, where I won't keep on just saying white middle class people were doing it, like I'll stop doing that. I guess if you want to abolish Section 21, abolish all private landlords with council housing and everybody wins, right? That's like, the way people, like Section 21 is a reform, but it already exists. Council housing is there. Don't be snobbish. And more council housing reduces the power of private landlords. The kind of anti-council housing classist attitude, like generation rent. Wow. You should be supporting those worst affected. Just more about white middle class people stigmatising other people. Sorry, I'll move on. I think that they're renting from respectable private lands. Anyway, so that was one point. Like, why have these little like modifications? Like, get to the root cause of it. Fight for council housing, support those. I guess my second thing that I've also touched on a bit is like the narrow framing of the campaigning hid the wider problems. Those less affected by the housing crisis. Section 21 isn't the biggest problem. Like overcrowding, unsafe conditions. The focus on Section 21 took away from that quite a lot because, like I said, they've got their nice homes that they're happy to live in. It's just the moving that's a little bit of an inconvenience. But it was this easy narrative, like this easy campaigning and media narrative, right? Who can, apart from me, who's being quite unreasonable, but like most reasonable people would not be like, you shouldn't, like no-fault evictions. I've got confused by no-fault evictions. It's hard to, you can't support no-fault evictions. It's hard to be like, I agree with no-fault evictions. So like, yeah, I'm kind of an unreasonable person to be like, I'm not really into it that much. But like, it's an easy campaign message. But campaigning and winning, right, isn't necessarily what's the best thing. So the Homelessness Reduction Act, the crisis, the housing homeless charity campaigned for, it's really not that good, is it? Like, they won their campaign, but actually most homeless families are now in like a way worse situation where everyone's really confused and stressed, and they're in the housing office where they have no other option, and like they don't want to be there, no one wants to be there, and they're being told, oh, is there anything you can do to help your situation? Like, why would we be sitting here if there were other options available to us, right? So don't just try and like win things. It felt like the Section 21 is like, oh, this is winnable. It's like, oh yeah, great, that's winnable, it's really nice to win. Actually, maybe not. The Homelessness Reduction Act has made things worse, arguably. So this focus on winning, it's like, and then in our group, we talk about overcrowding a lot, and it's so hard to make overcrowding sound interesting and urgent, and like, how do you make that catchy? But it's so, like, that's, so many of our members are overcrowding, it's so important. So yeah, I guess this no-fault stuff all became a little bit trendy. And other issues aren't as trendy, so do we just drop them? That's kind of what happened, but so yeah, and campaigning is hard when you're talking about these not very exciting issues like overcrowding, poor conditions, domestic violence, housing and health. Like ending right to buy, like that's an important campaign, but it's quite a tricky and difficult one. Just the kind of culture of right to buy. So even in our group, people are like homeless on the housing waiting list, and people are like, I've heard of this thing called right to buy. And we're like, wait a second, you're in temporary accommodation. This is so far from. Don't think about buying the council house that is so far away. So like that was a really difficult and interesting campaign, right? But I guess these are the, like, where Section 21 is just, oh, everybody, no evictions, like everyone can agree with that, and it's easy. So I guess in 2014 there was the Focus E15 campaign, and like Hassel was going on at that time, and they had their slogan, social housing, not social cleansing. So that was 5 years ago. And at that time, Shelter, the housing charity, were talking about affordable housing a lot. Like, oh, affordable housing, that's what we need. And after 2014 and Focus C15 and the housing movement, Shelter, a few years, started to talk about social housing. So now Shelter really talk about social housing. So grassroots organising does work, like it does have an impact, but it's really, really hard, and like, but we need to be supporting it. So like, I'll do little tweets from Hassel about these things that I think are really important, like, oh, we emailed the housing manager and he hasn't replied, and there's been these homelessness decision delays. Like, how do you make homelessness decision delays like sound exciting? It's not as exciting as end Section 21, like, but it's so important. And so yeah, and then like, it doesn't get that many retweets. I'm like, am I wording it badly? So I have to text around to all my friends like, please retweet this, it's really important, right? Campaigning on real issues is really, really hard. And so again, yeah, the Section 21 campaign, it just felt a bit easy, and like, to then all these other really important things just got a bit neglected. Another point is that it doesn't deal with the slum landlords in a way that access to better council housing does immediately. If we kind of like, we should put our energies into fighting for council housing, the Section 21 malarkey, it's all right, but actually, like, what are housing groups talking about? What are migrant action groups talking about? It's like safe, secure council housing. So yeah, in Hassel. In our group, private landlords find Section 21 an annoyance and an inconvenience. Like, there was a message that someone said where the private landlord was like, oh, I can give you the legally worded Section 21 if you would like, please call me, or something. Like, they don't want to do it. Like, people in the group have been illegally evicted, and the police helped her to gain entry. There was the guy with the fake claim form recently. So yeah, like the slum landlords that we encounter don't use Section 21 anyway. They can't be bothered. And actually it gives our members a bit of leverage when they're like, well, actually you need to do this. But yeah, we want council housing so slum landlords don't exist. Section 21 or Section 21, like, it won't change their behaviour of the dodgy landlords. And yeah, I guess, yeah, before Section 21, right, there were slum landlords. And they would look around for ways to get around the rules and the laws then. And I guess if you're housing people, I can't remember it, like Street v Montfort or something, like there was some important thing where in the 80s, before Section 21, landlords were always like taking away the rights and finding a way around protections that tenants had. And currently, right now, we have property guardianship companies like finding their ways around Section 21. So ultimately, Section 21 or no Section 21, I don't know, just give us all proper good council housing that we can all enjoy together and all benefit from. And is it not, maybe it's not necessarily making things more secure for private renters if we end Section 21. Again, you'll probably know more about it than me, but right now we're quite into the Deregulation Act stuff with the gas safety certificate, energy performance certificate. Like these are quite good things, and it's quite fun going through the checklist. Like that is stressful, but it's interesting. And it does bring the balance a little bit more to our side. Like I said, since the Deregulation Act, we haven't had a single valid Section 21. And if we take that away, then yeah, maybe we're not necessarily as private renters more secure. We quite like these technical defences. In the group we've regularly supported our members with them and like gone to court with them. It will be replaced with factual defences about the landlord wanting to sell their property or whatever. Yeah, and the deposit protection Section 21, they're also a form of enforcement for private landlords. What will replace that? Like the gas safety thing's wicked, isn't it? Is they're going to some court like in the next year or something where we want the gas safety. Like you shouldn't be able to rent if you haven't checked the gas safety. So that's all very exciting. Will we need Section 21 if the gas safety thing is successful? I don't know. Anyway, the gas safety thing. Maybe we'll be left with weaker arguments. Some of the things in the Deregulation Act were quite good. And I guess like looking over to Europe, everyone looks over to Europe. Oh, they have such better security of tenure. And but then in Germany at the same time, in April this year, there were protests in Berlin and other German cities of private renters. Where they have rent control and better security of tenure, but there were private renters who were protesting at rent hikes and like rent increases, and they were calling for private housing to be given back to the state. So it's like, well, if those guys who've already got better security of tenure in the private rented sector are calling for public housing, it's like, well, yeah, let's just go for it. Like they're a little bit ahead of us in Germany. Like they're leading the way. If they're saying that as private renters with better security of tenure, it doesn't really change much. They're calling for public-owned housing. Yeah, just go for it. Practical support and action now. I think some people are like, oh, Section 21 can act as a stopgap while we sort out the housing crisis. It will be useful. And it's like, okay, yeah, maybe it will be a bit useful. But all the energy and like it's taking a lot of time and energy and enforcement and all of these things when we could be doing better things. Like, yes, making sure people have proper benefits, like migrant rights and council housing now. Like, there's nothing stopping us from demanding and organising on all of these things now. So those are some of my sort of thoughts and frustrations, and if we get better council housing for everyone, the private rented sector will just be out of existence anyway, which is what we all want.
Thanks, Izzy. Well, I'm sorry, I should have started by introducing myself, but I forgot. My name's Nick Banner, and like David, I'm a barrister specialising in housing and accommodation-related issues. And like Izzy, I'm a member of Housing Action Civic in Lambeth, and I'm also on the Haldane Executive Committee. And you've heard from David that the end of Section 21 is going to be a sea change that revolutionises the private sector. And you've heard from Izzy that it's a pathetic middle-class whining concern. And because I'm a pathological people pleaser, I'm going to try and agree with both of them, and I'll see how I do. I'll start by explaining why I think it's so bad, because I've been talking about Section 21 since about 2013, when it was about the nerdiest thing you could tweet about. There's very good research to show that insecure housing leads to mental ill health. And Section 21 is also the single biggest recorded cause of homelessness. So abolishing it will have very, very real consequences for an awful lot of people, because the private rented sector is huge and growing. But more importantly, because of the economics of the situation, Section 21 has a huge effect on everyone, whether they're in the private rented sector or not. It really is, I think, the crux of the housing crisis. And to understand that, we need to understand a bit about why it is so bad. And it's, I think, because of something called the rent gap, which is something that housing economists use to explain gentrification. And the rent gap is where you have a piece of land or even a particular unit of accommodation that is a lower value than the land that surrounds it. The landlords can see a difference, and they know that if they take some action, they can raise up the money they're getting and bring it into line with what's around it. And typically in cities like New York, that involves things like rezoning, sometimes it involves knocking buildings down, sometimes it involves illegal evictions, whatever it is. But this is how the Trump family made a lot of its money. It would buy up railway land in Manhattan when there was still railway land there, and it closed the rent gap by waiting for the railway companies to fold, and then it would rezone it as commercial land and residential land, and it closed that rent gap. What's phenomenal is that the existence of Section 21 in England and Wales means that you can close the rent gap almost instantly. Within 6 months, you can either evict someone or say to them, I'm demanding a new rent, and if you don't pay the new rent, you know what's going to happen. So Section 21 is gold dust for landlords. And what it's done, its existence since 1988, is turned houses into an incredible financial asset. That's what fuels the current housing crisis, and that's what causes poverty. And before I move on from the rent gap, it's important to note how prejudiced and racialised the whole process is, and there's two particularly striking examples, both from the US. The first is Central Park in New York, which, when the city was young, was the only neighbourhood owned by black landowners. It was owned by free black people. It was called Seneca Village. And it so happens that Seneca Village was the district that was torn down to build Central Park, and the residents and the owners were displaced and relocated in order to close that rent gap. And the second is in a much broader scale, because under the New Deal in the 30s, there was wholesale planning reform in the US. And every neighbourhood, every single district was assessed for risk so that mortgage lenders knew what the risks were. And there's a good recent book about this called Capital City by Sam Stein, and he points out that one of the factors in assessing risk was racial composition. And this is a quote from Stein. He says, Jews were considered communistic and likely to go on rent strike. Italians were characterised as dangerous gangsters. African Americans were written off entirely, and virtually any block with black people was given a low grade. Now, those mortgage ratings led to disinvestment and decline, and then 30 years later, in the 60s, 70s, 80s, you got the displacement and the social housing and social cleansing, when landlords and owners closed that rent gap between poor districts and the rich districts that surrounded them. And it's very, very easy to see the parallels, particularly here in London, when we look at places like Hackney and Brixton and Elephant and Castle and the Old Kent Road. But the difference between the US and the UK is that Section 21 turbocharges it. You can just close that rent gap as soon as you like. Whenever a landlord in Brixton sees the prices go up around, they can close the rent gap. It's also important, I think, from a hassle perspective, to find out why they're stuck in bad private rented sector accommodation in the first place. And again, that turns an awful lot on the existence of Section 21, because the whole purpose of the regime, as we've heard about from David, was to commodify housing. We had these twin evils in the 1980s of Section 21 and the right to buy, which led to a massive change in the landscape of housing provision. Local authorities had previously been the focus. They were the providers of housing. They were the providers of accommodation. And that shifted so that private landowners would provide accommodation. So social tenure went from about 30% in 1970 to less than 18% today. And on the one hand, of course, that's because right to buy got rid of about 2 million council homes. But Section 21 is probably more pernicious. The shift to privately provided accommodation has been described as asset-based welfare. So the government, instead of spending money on social housing, is spending money on housing benefit and putting money in private landlords' pockets. And in order to do that, that's not its ultimate aim, obviously. Its aim is private provision of housing. But in order to achieve that aim, it tinkers with the economics to incentivise the private sector to provide the homes. And that's what it does through Section 21. It says, look, you'll have a problem-free eviction. You can have this thing that gives you free money every single month. And the price of it goes up every single month. It's going to be fantastic. And obviously that incentivises high house prices, both buy-to-lets and owner-occupiers. And Section 21 is the mechanism that makes that happen so very quickly. Of course it happens all around the world, but Section 21 really does boost the rise in house prices and the rise in the cost of living. So our members in Hassel are in bad temporary accommodation because the councils can't build council housing, because the government has instead for 30 years prioritised a private rented sector provision through Section 21, and the rents keep going up because of Section 21. And Lambeth and Southwark aren't interested in building council housing. It's not in their interests. They want to decrease their spend and increase their revenues through gentrification, which they can do enormously effectively through the existence of Section 21. He's absolutely right that council housing and Section 21 are two sides of the same coin, and absolutely we have to campaign for more council housing. But it's important not to underestimate the economic effect of Section 21. I particularly agree with Izzy about slum landlords because, as I understand it, the white paper that was published before the 1988 Act was specifically targeting slum landlords. We had a very different landscape back then when council housing was good, private housing was cheaper but worse, and the government wanted posh private housing. It wanted nice places where people would want to live, which, to be fair to them, it achieved. But at the same time, it created this huge, terrible bottom end of the private market, and it's exploded slum landlords instead of eliminating them, while at the same time installing fancy private rented housing. We've heard that it was a bolt from the blue, and I think that's absolutely right. This is where I disagree with Izzy, that it was easy to say, oh, let's abolish no-fault evictions. No one was talking about this. So under Ed Miliband, for example, the most radical thing he ever said was family-friendly 3-year tenancies. And that was the most radical housing proposition from any party in 30 years. The Cameron government picked it up, the May government picked it up, but nobody ever went further. And I have to say, Shelter and a lot of campaigning organisations have been really, really bad at radical housing demands. But for one reason or another, at some point this year, the Labour Party picked it up and ran with it, the Tories picked it up and ran with it. But it's interesting to find out why it hasn't been addressed before, and we can find the answer to that in the, partly in the questions that the consultation gives, because it preempts the answers, and partly in the answers that the Residential Landlords Association and others are already giving. They say that if you regulate the private sector, landlords flee the market. That's what we constantly hear. And of course that, if true, is a legitimate concern, because housing is a phenomenally important part of the UK economy. We only need to look at what happened to the US in 2008 to be reminded of that. And that's premised on an absurd notion that landlords are service providers. That's not true unless they're building houses. I mean, their function is the opposite. Their function is to own and withhold from us one of the most important things that we need. And there was a good report on this myth of disappearing landlords the other day. And I'll read a quote from it. It says, "Some landlords will sell up as letting becomes less lucrative, but at the end of each sales chain is either another landlord or someone who was previously renting. If it's another landlord, aggregate rental supply and demand are both unchanged. If it's a new owner-occupier, the supply of renting has shrunk by one, but so has the number of renters. The tightness of the rental market, and thus rents, are unchanged." This isn't a Marxist economist, this isn't the NEF, it's just the Bank of England's financial research. So the Bank of England is telling us it's fine, regulate the private rental sector, do what you like. The houses are going to be there, the landlords may or may not be there, it doesn't matter, no worries. And that, I think, is really, really important, particularly when we come to responding to the consultation. And before I close, I'll just make a quick confession that I'm going to miss Section 21 when it goes, because Izzy's right about the technical defences, and it's particularly satisfying as a housing lawyer because you have these landlords, and the government's told them that they cannot lose. The government said, you've got an absolute bang to rights eviction, don't worry about it. And then you turn up at court with a technical defence and you watch the colour drain from their face, and it really, really is wonderful. The amendments to the legislation are fertile ground for technical defences. And whenever I do training on Section 21, I show the clip from The Simpsons where Sideshow Bob steps on a rake, and then it zooms out, and he's just completely surrounded by rakes, and wherever he goes, he's going to step on a rake, and it'll hit him in the face. But of course, that's not an excuse for security of tenure. That constantly fighting battles and constantly losing them is not good for mental health. It's not good for stability. And Section 21 really has to go. It's, I think, particularly striking that this proposal was brought in by the May government, because Theresa May was also responsible for the racist right to rent mechanism. Now that, while it's horrible, really is quite a small part of society. whereas Section 21 was the key plank of Thatcher's housing reform, and housing is one of the things that underpins our economy. So the introduction of this policy shows one or two things. It either shows what David said, which is that the government's really worried about how to attract the millions of voters who are trapped in private rented accommodation, or it shows that Theresa May was genuinely more interested in racist violence than in a massive part of the UK economy. And I'll leave you to judge that one for yourselves. But whatever the reason, we've got to take advantage of the consultation. Of course, it's got to go hand in hand with campaigning for council housing. But the end of Section 21 is, I hope, going to be a sea change in housing economics. I'll leave it there, but we're very happy to take questions.
I think that is the sort of genesis of a strategy and a way in which the collective nature of the housing groups, or maybe the London Renters Union or trade unions, can get together and push labour further than it has gone, and much more in the direction that he advocates. So maybe just your comments on that.
I have a question on how to make sure tenants are best protected under the new grounds. So, for example, I guess, and this is to any of you, but how the technical grounds can best be replicated, or something else that would do the same thing, and then similarly in cases of rent increases or a landlord needing to sell, what you would all think would be the best way to put some sort of protection against a mandatory court order for tenants in this new system.
And then one from Luke, and then we'll answer.
Yeah, more with Nick and highlighting that there were talks, and there were recent talks before the end of Section 21 about instead going for longer fixed term, minimum fixed term tenancies. And just kind of, if any of you have views on, actually, in terms of your average private renter's security of tenure, which do you think would have been better? The current proposals when Section 21 were actually fixed, minimum fixed terms of 3 to 5 years.
There were talks about longer minimum fixed terms and which is preferable between the abolition of Section 21 and longer minimum fixed terms.
All right, okay.
Yeah, with the kind of the new grounds of eviction that being discussed, with the new what actually would have given people longer security.
Yeah. Okay. I'll be as brief as I can in dealing with the issue. Could I just ask your indulgence, because there was a point in my speech when I said very grandly, and I'm going to make 2 points, and then I made one of them, and then my writing was so small that I couldn't read it myself when I was speaking to you. But the point I wanted to make was that in the case of the ground for possession brought by the landlord because he wanted, or a member of his family wanted to live in the property. There's a specific provision in the Rent Acts that if an order is obtained on that ground and it later turned out the landlord had misrepresented the position or given false information, then the tenant could apply for compensation and for the loss that she had suffered as a result of the order being obtained. And that provision isn't replicated in the other housing acts. So since the consultation paper is talking about extending the landlord wanting to occupy or have the tenancy for occupation by members of his family, that is something to bring up in response. I think if that is brought in, then there'll be provision for the tenant to obtain compensation. Reinstatement could probably be a long shot, but at least compensation if the landlord gets possession on that ground and then doesn't move in or a member of his family. Okay, so to take your points, collective action. Yes, it's been something of a frustration throughout the time I've been involved with the housing field, that tenants and occupiers have not had the same organisation and representation as traditionally existed in the employment and trade union area. Rather less so recent years, of course, than back in the 70s and 80s. But it is much more scattered and much weaker in the housing sector. That isn't to say there aren't areas of strength. I've had cases where I've represented residents' associations in private rented blocks, and that's particularly on rent registrations, but also on agitating for repairs. Equally, of course, in public sector blocks, we've had active tenants association either related to particular estates or all borough-wide. But a nationwide or county-wide that kind wide has not, it seems, been possible to achieve. Funnily enough, I was just recording this earlier this evening. When I represented squatters, there's an all-London squatters union which met regularly and was vigorous in, obviously, dealing with occupations, court cases, and looking out for empty property that could be utilised at homeless. So that time, of course, that with increasing legal pressure, which has made squatting less viable. Though it still exists, much more exists than you may be aware of. Yeah, so that's feelings about that. What can be done to assist tenants in relation to security, particularly in relation to rent? Oh, that's a tricky one, because we're really talking about information in the first place as to what rights and obligations are. In relation to rent, of course, the rate of rent depends on market forces. There's very little individual tenant can do that. But the scope for registration is going to become much wider if this proposal goes through, because in much more in tenants' interest to get a rent registered, and even though it is a market rent to be registered, it's going to be the market rent that the assessment committee rules rather than the landlord considers. And the last, what is the advantage of fixed-term tenancies as opposed to periodic tenancies? That's an interesting one, because it was the consultation that we were dealing with last year was really inviting the consultees to say we would like fixed-term tenancies of a particular length for these particular reasons, and that would give tenants in the private sector greater protection. One of the ironies of that consultation was there's actually nothing in law to stop landlords granting long-term tenancies. The fact of the matter was there weren't tenancies as a rule longer than 6 months or a year, because landlords weren't granting them. Because they wanted freedom to refix the rent at the end of the short fixed-term tenancy. from a tenant's point of view, the long-term tenancy, 2, 3, 4 or 5 years, gives that amount of security from eviction, because the way it fits in with security, if we have the same process as we do with the current Housing Act, 1988, is that the grounds are not going to kick in until the tenancy is terminated. So there is additional protection in relation to the fixed term. What is raised by the consultation paper is the suggestion of a break clause within the fixed term, which is that at a certain point, say halfway through the tenancy, the landlord or the tenant can opt out. So it'd be terminated prematurely at that point. But I think it really depends from the tenant's point of view on what the tenant is looking for. If you're looking to stay, put down roots in the area, then go for the longer fixed term. A fixed term is nearly always an advantage. Even a 1 year fixed term is an advantage, because at least you've got the year. Now, were those longer answers than I said I was going to give right at the very beginning? Probably. But anyway, those are my comments.
I can speak a little bit about like practical organising and sort of solidarity and sort of movements and groups. Hassel is politically independent, but like what Labour is saying at the moment is very exciting. And like 7 years ago or something, I was at a Welfare Reform Act demonstration outside Parliament, and there were like 10 people, and then John McDonnell. So like props to John McDonnell. So I feel like I should like big him up and like support him. The Hassel is completely politically independent, but like I owe him one. So yeah, I guess on terms of organising, it's this issue of capacity. Because rents are so high, people are having to work so much. People don't have time, like as much time to sort of support local housing groups and like migrant action groups and all those things. Hassel started because me and a mate were squatting, so that gave us the free time to start this housing group, and like the long-term commitment and energy and time that went into establishing the group. So that was 6 years ago when Hassel first started, and we've been organising since. But it wouldn't have happened without squatting, because we would have had to be going to work to pay rent. So yeah, in London, in terms of organising practical solidarity and support, it seems really tough because everyone is working to pay rent. Aquaba is a migrant social centre in Hackney that happens every Sunday, and last Sunday they had to close because they didn't have enough volunteers to look after the kids. And they have like most of the people who attend their group are migrants with no recourse to public funds. And it's like, I've never been, but I always look at pictures and hear about it, and it looks like this incredible event every Sunday. But yeah, they just didn't have enough people who could give up a Sunday, and regular too, so the kids have that continuity. And same in Hassel, we were really short of childcare volunteers. So yeah, all these projects that are sort of supporting those worst affected are in like dire need of support, like practical support and help and childcare and sort of financial support. So it is a really tough time to be organising. And Aquaba is also where the legal challenge against the Home Office deporting Rough-sleeping EEA nationals came out of. I think at Aquaba they noticed, and then they heard people speaking about how Eastern European rough sleeper members of Aquaba who attended the social centre had been like chased by the Home Office, and then that legal challenge came from Aquaba working with Public Interest Law Centre, and it was 2 years ago, wasn't it, like December 2017, when the Home Office's actions were found to be unlawful. Since then, people have got like good compensation, like money for what happened to them, not enough, but still a significant, like not real justice, but something to acknowledge. And so that's why, like grassroots groups, like organising practical support of those worst affected are so important. But yeah, they're also really, really struggling, and that's because people are having to work and everybody's struggling. But yeah, the situation at the moment is feels quite bleak, but these groups and campaigns, and they are still going, and people are interested in supporting, even just retweeting, so they don't have to text people. I have a couple of friends, and I pretend I'm doing a mass text. I'm like, "Hi friends, please retweet my hassle tweet," and I'm like just targeting people. So I guess we're quite desperate or open, or there's just lots of ways to show support. Like join the housing register in your local area, right, to show there's demand for council housing. And if you're in sort of suitable housing, you'll be at the bottom anyway, so it's not that you won't bid successfully for a council house over someone else, so you don't need to worry. But you're just showing that there's demand for it. Councils have been doing their policies to do everything they can to shorten their list, so if we can all help it grow, that's a good thing. But there are lots of practical, quite simple practical things that we can be doing to fight the housing crisis right now. Whatever happens with Section 21 in the future, there's so much that we can do now.
Could I just comment on those in reverse order, and then I'll take three more? On the point about longer minimum fixed terms versus the end of Section 21, I think legally they're mutually inconsistent. And I don't think, because when the fixed term comes to an end, how do you end the tenancy in court except for by Section 21? And I don't think the government's quite got its head around that, because when Labour and then the Tories announced the policy, they said, yeah, we're going to abolish Section 21. And then you heard statements from the ministers who were like, oh, hell, what we meant was longer tenancies, we'll work out the details. But I think it's important to note that you can only have one or the other, and we've got to push for the abolition of Section 21. On the how to make sure tenants are best protected under the new grounds point, it's important not to give the game away at this stage and tell the landlords what kind of grounds we want. I mean, we don't want any grounds. And when they come back to us and say, well, what about this? We can critique that. But it's important not to go too far in that respect. And on the rent increase thing, David's right. And I think the other thing that the government doesn't quite realise is that abolishing Section 21 basically brings back a form of rent control. Because when you can't get evicted by Section 21, you can go to the tribunal. So when you fill in the consultation, don't tell them, but that's quite an exciting move as well. And on the point about collective action, yeah, there's a really proud history of it, and we've heard about the Clyde, and around the corner in St Pancras in the 50s there was a big rent strike when two communist tenants organised a rent strike, and they were evicted and then put back in by a massive movement of people. But the problem when you lack security of tenure, I often compare it to employment. Imagine if you had a job when they say, you've got all these rights, you've got 12 weeks holiday a year, but we can fire you at any time for any reason. No one's going to go on strike. So unless and until we get security of tenure, the private rented sector is really precarious. Can I take three more questions?
Maybe it's because I'm very cynical, but I'm just concerned with some of the things that you've mentioned in respect of the grounds for terminating a tenancy without Section 21, and that being widened. I think some of the things that I've seen is generally a wider sort of rollout of things like introductory tenancies and flexible tenancies for council flats. I'm just worried, maybe because I don't trust the Tories, that they're going to widen the scope, and then, as you said, they applied the same grounds for ending a council tenancy to then being the other way around. I'm just concerned that they're going to use a widening ground in respect of private tenancies through this idea of what security means in 2019 or the 2020s, and then apply that in order to, let's say, for instance, if they want to sell off their stock, something more equivalent to the idea of, a private landlord selling off their stock of housing, but then obviously local authorities trying to make up their bottom line and selling off their housing stock. Is there not a risk of us sort of being pulled down by this?
Any more in this room?
Okay, well, I'll take Natalie's question then. It's a very good point, and I think really underlines the need to oppose new grounds in this consultation, because I think you're right. We've seen this kind of creep for that. What gets applied in one sector then gets applied to the other another sector, and I think that's a very real risk that if grounds are widened in the private sector, that will roll back on to the public sector as well, which is absolutely under pressure as it is with regimes such as the introductory tenancy and demoted tenancy in the course of a secure tenancy, and we've seen the increasing scope of the antisocial behaviour grounds in the secure tenancy, which has then bled into the private sector as well. So I think that's a very good warning that you've given there. Not that you wanted to scare us, of course. But,
I was hoping for something
well,
more positive.
you pointed out the possibility.
Can I add one thing to that, which is that if this happens, this is where campaigning becomes really important. And there's a good example of this recently, because there's a ground called 7A. I can't remember what it is in the council regime, but if someone's done a particular thing, for example, breached an antisocial behaviour injunction, then the landlord has what's called an absolute and mandatory ground for possession. And about 6 months ago, Islington Council said, oh, we're really concerned about antisocial behaviour, we're going to start using these. And everyone kicked off, and a homelessness charity and the CRP branches passed a load of motions that said, don't you dare. And the council said, oh, sorry, we didn't mean it. So now if they ever tried that, David and I have bang to rights public law defences that said, you said you wouldn't do this, so you can't. So if that happens, that's where we all step in. Any more questions? In that case, then, can I just ask you to thank our guests very much indeed.